Welcome once again to Lehto's Law. Here's Steve Lehto.
Steven with a PH sent me the story. Says, Steve, check this out. It's from Michigan. Michigan man wins long shot appeal over burglary linked to his DNA on a bottle. Ed White wrote this to the Associated Press. And you might say, Steve, somebody winning an appeal? That's not that big of a deal. Oh, it is. It's a big deal. It's a big deal. He did it himself. And that right there, my friends, makes it a little less common. Michigan prisoner has persuaded a judge to toss his burglary conviction, overcoming long odds by serving as his own lawyer in an appeal of a case that rested entirely on his DNA found on a soda bottle in a beauty shop. Now, Ed White, not sure if he's from Michigan, but he refers to it as a soda bottle. In Michigan, we call it a pop bottle. The man's 65 years old. He argued that the DNA wasn't sufficient on its own to convict him in a 2016 break-in near Detroit. And he cited the U.S. Supreme Court rulings and some other stuff about evidence. And U.S. District Judge David Lawson agreed that the case against him was too thin to stand. So in case you're curious, the man's appealing this in U.S. District Court because presumably he's doing what's called a habeas corpus action. Habeas corpus is Latin, of course, and it's a term for, back in the old days, to present the body, corpus, body. And in the old days, if you got arrested, I'm talking about in the old days, you got arrested and you're being held, you could always appeal to really, really high powers to say, hey, I'm being abused here legally, and I need someone else to take a look at this. So in America, what you do, if a state court convicts you and it's a wrongful conviction, but the state courts won't give you any help, you appeal through the federal system. And you ask the federal system to look at it and determine whether or not you're being held is a violation of your constitutional rights. And he's saying it was because to be convicted on such thin evidence was wrong. So the judge wrote, any inference that the man must have deposited his DNA on the bottle during the course of the burglary was pure speculation, unsupported by any positive proof in the record. So a lawyer who has spent 30 years at the state appellate defender office who's not involved with the case said what this man did was not easy. I'm just impressed that this is a man who had enough confidence in himself and his legal skills to represent himself with a habeas claim. So the petitioner argued that a guilty verdict violated various protections spelled out in federal law and the Constitution. Success is extremely rare. A man was accused of breaking into a beauty shop in Ferndale in 2016, and somebody stole $10,000 worth of supplies, along with a television, a computer, and a wall clock. Now, he was charged after his DNA was found on a Coke bottle at the crime scene. Authorities, however, found other DNA on the bottle that they couldn't match with anybody. So to say, well, his DNA is there, he must be guilty. What about the other people on the bottle? And that's where you go, oh, wait a second. I suspect they're not in the database, right? So speaking from prison, the man told the Associated Press that he's overwhelmed by the ruling. He said he has no idea how a bottle with his DNA ended up over there. Remember that in Michigan, pop bottles carry a 10-cent deposit. You know that if you watch Seinfeld. A pop bottle has monetary value, the man said, referring to Michigan's 10-cent deposit law, and also he called it a pop bottle. You can leave a bottle on the east side, and it can end up on the west side that same day. His victory hasn't meant he's been freed. He's still serving time for a different conviction and has to appear before a parole board on that one. Prosecutors, however, are not giving up because they don't do that. The Michigan Attorney General's office said it plans to appeal a decision overturning the burglary conviction. So this case boils down to quite simply one fact. One fact. There's a crime. Police come in and are investigating it, and they find a pop bottle at the scene. What's this pop bottle doing? They examine the pop bottle, and they get DNA off of it, apparently from more than one person. They run those profiles through the system, and up pops this guy. They arrest him, put him on trial. He's convicted of burglary based entirely and solely on that one fact. Remember that, for a conviction to be good, it's supposed to be beyond a reasonable doubt. Beyond a reasonable doubt. And is his presence with the pop bottle, and the pop bottle now being at the crime scene, is that evidence beyond a reasonable doubt that he committed the burglary? And I agree with the federal court that says, no, that's not enough. That's not enough. Now, if his thumbprint had been found on a countertop, for instance, I'd go, oh, okay, unless somebody carried the countertop in. But pop bottles are very portable. And what he's saying is absolutely right. People do carry them around. I've got a bunch of them in my car right now. I got bags of them in my house. They're the scourge of the consumer world. But I do return them. But I can also tell you, people go out and pick them up and return them. It's more a matter of, does this prove that he did it versus does this just indicate he might be a good suspect? And so I would have no trouble if you said, Steve, they found the guy's DNA on this pop bottle. They've decided to question him. They've decided to bring him in and ask him questions. I'd have no problem with that. But to suggest that you can get in front of a jury and convince them all to vote, yes, beyond a reasonable doubt, this man's guilty based on that, that's a problem. And so you have to understand another thing, is that a lot of people, it depends on what communities you're in and so on, but a lot of people put a lot of faith in prosecutors and the police. And so when the police come in and testify and the prosecutors ask them all these questions about, explain to us how you discovered DNA and what does it prove and what are the odds that it's someone else's DNA and all this. And no one's questioning the DNA science here. We're just questioning, what does it mean that his DNA was found on something portable at the scene? And I know you're going to say, Steve, but what are the odds that someone found a pop bottle that he touched and brought it into that salon during the robbery? It didn't have to come in during the robbery. Who said that? It was found in the building. Maybe been brought in the day before or a week before. Who knows? Who knows? And as he pointed out, these things do travel around. And so it's thin evidence. I agree with the judge on that. And I can tell you, I've read a few habeas corpus motions. I've studied some of them. I've mentioned before that Timothy Masters, the guy who spent 10 years in prison for a murder he did not commit, and he and I co-wrote a book together about his experiences called Drawn to Injustice. And he had exhausted all of his appeals in the Colorado state system, and he couldn't find anybody to handle his own appeal. And he filed a motion in the federal court, a habeas, and he got it granted. And now his case, likewise, extremely thin evidence. And I can tell you that in later years, he spoke to jurors. Jurors came up to him who'd been on his case and apologized. At least one did, but I think he may have spoken to more than one. And told him, well, we knew the evidence was thin, but we assumed they had more evidence. What do you mean you assumed they had more evidence? And so you can't predict what jurors do, and you also have a hard time deconstructing what they did after they've done it, because you don't know what goes on back there. And I've heard of people voting one way or the other just to get out of there and go home. It's 11-1, and you're the one, and you think to yourself, well, I'm not going to convince 11 people to change their minds. I want to get home and watch Twin Peaks. Back in the day. So the guy decided to do this on his own. Now, I have to tell you, there are people in prison who have got a lot of time on their hands. And I can also tell you that, unfortunately, many of them spend their time drafting motions, filing lawsuits, and creating paperwork and filing it with the system. And I don't know what the numbers are, but I've heard they're larger than you'd expect, of inmates filing legal documents. And the vast majority of them are not impressive. And so for this guy to do this, it is impressive. And I haven't read his habeas motion. I did read Timothy Masters, and his was very good also. And so it can be done, but it takes a lot of work. Now, they don't mention which Supreme Court case in particular he cited to, but apparently there's a key one. But it boils down to, they found evidence that he had touched the Coke bottle, and the Coke bottle was found at the scene. No evidence of how the Coke bottle got to the scene. Is it a long shot? Yes. But is it a long enough shot to say, yes, that guy committed that crime? I'd have to say no. I wouldn't be convinced. But apparently a jury was. So a federal judge just spun that around and said, no, that's not enough. That's not enough. So they can appeal it, The appeal, of course, will go to the Sixth Circuit Court of Appeals. We'll see what they do. We'll have to watch and find out. As of right now, though, the man's conviction has been overturned. Stephen of the PH, thanks for sending that from the Associated Press and Ed White. Michigan man wins long shot appeal over burglary linked to his DNA on a pop bottle. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. You've mistaken my microphone for a feather duster? No, I'm not his cleaning lady.